case number 20 of 2019.
And they were explicitly made to apply to
Both case number 18 and number 20. All along, both files were always kept together, Your Honor, before Honorable Mr. Mr. Ogoti, sorry.
So your view is that pretrial has been
Yes,
done
yes,
and the
yes,
pretrial
yes, Your Honor, yes. Yes.
So you are asking for hearing?
Yes, we would really like hearing dates, Your Honor. We've been waiting since 2019, Your Honor.
Okay, thank you. I think I will ask the reaction from Ms. Munani.
Your Honor, it's Miss Muthiani.
Muthiani?
Yes.
Oh, sorry.
Yes, Your Honor. And I want to totally associate myself with the statements by my learned senior, Mr. Katwa, and say that, Your Honor, the purpose of today's mention was quite clear. It was for fixing hearing dates. So, Your Honor, we are ready to have hearing dates for this matter. And, Your Honor, for the record, my clients reside in Eldoret.
Yes.
And every time this matter is coming up, whether for mention or for hearing, or rather for mention, they have to travel all the way, Your Honor.
Yes.
DPP was granted 14 days within which to amend their charge sheet, and up to date, Your Honor, they have not served us with any amended charge sheets, Your Honor. Yes, Your Honor, that will be all.
Thank you.
Thank you.
To date, the prosecution has yet to kick off on the trial. I can also confirm that the directions issued by your brother, Mr. Ogoti, were that the pre-trial directions issued in case number 20 of 2019 do apply in this matter. Your Honor, I also appreciate noting that we are among the parties who made an application for review of the charges against the accused persons we represent way back in February. We appreciate that the DPP has now sought to review the said applications. We are grateful in as much as it has taken a while and we know not of the outcome. We are amenable to giving them time, but in the intervening period, Your Lordship, we can take hearing dates in the matter just to secure the liberty of our clients because it has taken a while. And that will be all for me.
Coming in late, my name is Mr. Sige.
Sige?
Yes, I am on record for the 9th accused
So
person.
the 9th?
Yes.
They forgot to mention
When I was actually going around the courtrooms, I was unable to trace this particular courtroom in good time.
Oh, sorry.
Kindly place me on record for the 9th accused. He is present in court.
Yes.
And I would like to react to what...
I'll call you to react after Mr. Gashaka.
All right. Thank you. Thank you.
Yes, Your Honor. This is on behalf of the 7th accused person,
Yes.
after listening to submission by the Office of the Director of Public Prosecution, I am one of the counsel who intend to make an application for review for the decision to prosecute the 7th accused person. And in that light, and in as much as we want to take hearing dates, I believe it would be prudent, even if such hearing dates are taken, a date for mention is fixed in between for the prosecution to confirm whether it will have made a decision and on whether it will have made review of our applications. So that, Your Honor, my views are that we could proceed to take hearing dates,
Yes.
but have, I mentioned it in between,
Yes.
for mention to confirm status of the various applications that shall have been made by council to DPP for review. That is all for now.
Up to speed as to the issues that were raised. Pursuant to the directions which were given by your brother, directions on retrial had been taken, which were to apply to this particular file. And we were, upon the file being transferred to you, to appear to take a date for hearing, or other dates for hearing. There was an application at that time by the prosecution to amend the charges. They had requested for 14 days. We of course had no issue as at that time. What we were waiting for were to be served with those proposed amendments for us to take appropriate directions. We are yet to get those amendments in the charge sheets that were already brought before court. We were therefore appearing before you today for purposes of taking hearing dates. We would urge Your Honor to slot us for hearing of the matter because of what has been submitted before you by my learned senior and other colleagues, that it is over 2 years now when these accused.
Did we forget you?
Yeah, Kimai.
No, you were still there. You were still get to you. I think it's your turn now.
Okay.
Kimani.
So,
Figure was for the 9.
Yes.
Yes. So we didn't forget you.
okay.
Yes. Kimani, you can make it.
Okay. So, Your Honor, I fully associate myself with the sentiments of my learned senior, Mr. Bashama,
Yes.
for the review of the decision to charge.
Yes.
And we are not, as much as we are not opposed to the submissions made by my learned seniors to take a hearing date, we would pray that in the intervening period, that we get a mention date, whereby the prosecution, and then we can proceed to now taking the hearing date. So in the meantime, we can have the hearing date, and also a mention to confirm the status of our applications. Thank you,
Honor,
Yes. Thank you.
I am taken aback by what has been submitted by my learned colleagues from the defense for several reasons. Number one, and we would like to make this crystal clear, the DPP is not asking for any adjournments, and the DPP is not asking for any delays, nor has the DPP been the cause of any delay that has been occasioned in this matter. But rather, the courts were rendered inactive for quite some time due to the effects of the COVID-19 pandemic. All we were asking, Your Honor, is that this matter, which is already scheduled for mention before you on the 29th of September, it's already listed for mention on 29th of September. It's not a new date that we are asking for.
Yes.
We are asking you to confirm that mention date so as to allow the DPP, who is bound under the Fair Administrative Actions Act, and who is also bound by the constitutional provisions relating to fair administrative actions, to consider and respond to applications made by these very same accused persons before you. Now, I would like to believe, Your Honor, I would sincerely like to believe that counsel for the defense is aware that their clients have made applications to the DPP for review of the decision to charge them.
Yes.
And if they are not aware, then it is catastrophic.
Yes.
Because the assumption then will be that the clients are acting independently of the legal advice from their counsel. And this is an important factor that the DPP will need to take into consideration in making up his mind on the requests. If they are aware that they have requested the DPP for a review of the decision to charge, then they must be aware that the DPP requires time to make a substantive review that satisfies the requirements under the law. Because the DPP is a constitutional office that is mandated to act in accordance with the law and not by whims and caprices of the office bearer. It is therefore critical, Your Honor, if the constitutional safeguard to fair administrative action is to be implemented, and if the provisions of the Fair Administrative Actions Act are to be adhered to, it is important for that mentioned date of 29th to be maintained, and for the DPP to have the opportunity, reasonable opportunity, to consider and respond to the applications that the accused persons have lodged with him. Alternatively, the accused persons can now put it on record that they no longer require the reviews and we can proceed immediately with the hearings.
Yes.
We are not worried about the hearing. We are ready to proceed with the hearings. So if they can confirm now that they no longer want the DPP to review the decision to charge, we are ready to proceed with the hearing. If they are not withdrawing their requests for review, then let us have the mentioned date on the 29th of September for the purpose of fixing the hearing dates. Will, as you will agree, Your Honor, depend on the outcomes of the review or the reviews. Finally, Your Honor, if you are persuaded, or before I get into, also apply to this case number 18. That is partly true and partly not true. At the last mention, when we appeared before your brother, Honorable Mugambi, he stated that he was not satisfied with the directions or the pre-trial directions that were made by your brother, Honorable Ogoti, and he proceeded to add further directions that he was convinced would lead to a more expeditious disposal of the trial. So it will be foolhardy to close the door on Your Honor. Your Honor ought also to look at those pre-trial directions and the additions made by your brother, Honorable Mugambi, and make up your own decision as to whether you will require to amend those pre-trial directions or maintain them in your wisdom. Lastly, if you are persuaded, Your Honor, by my learned colleagues and are inclined to grant hearing dates, we will not be averse to that. We are not averse to the taking and fixing of hearing dates, so long as the mentioned date of 29th of September is maintained.
That we have filed revision number 5 of 2020, which is coming up for hearing on 20th of September.
Is that a revision number?
5 of 2020, coming up on 20th September, challenging the directions by Honorable Ogoti. So even as my lawyer friends seek to persuade you that directions have already been given, it is important to keep it at the back of your mind that the High Court is already seized of the matter regarding those directions. And therefore, the more reason why 29th, the date of 29th, needs to be maintained, just in case the High Court directs otherwise. But that's
About the issues, this is the ruling. I've considered the submissions by counsel. The key issue emerging is whether this matter is ripe for fixing of hearing dates. I note that as indicated by counsel, it is now in the region of 2 years since the accused were arraigned in court for plea. And despite that duration, there does not appear to be a finality on the charges that should be the subject of trial, which is surprising actually. And even the precise accused persons who should be subjected to trial. As such, the plea that was taken cannot be deemed in those circumstances to be final, even for purposes of pretrial. Directions that are themselves the subject of, even for purposes of pretrial directions that are themselves the subject of dispute. I note that the pretrial directions were taken in another matter, which is Anti-Corruption Court number 20 of 2019. It is not clear how the final charges that constitute this matter eventually would bear on all or some of those directions, especially on the important question of disclosure. It is submitted on behalf of the state and conceded by certain accused persons through their counsel that they have sought review of the learned DPP's decision to prosecute them. It is indicated that the matter is under consideration and the learned DPP seeks reasonable time to complete it. It goes without saying that the decision reached may impact on the charges already filed and pleaded to by the accused persons. Thus, while defense counsel contend that hearing dates should be fixed, it is emergent that the precise charges that should be the subject of that hearing are not agreed or before the court. So if we say we fix a hearing date, and we have issues pending surrounding the charges, so what are we trying? I think that's an important question for counsel to consider. Equally, the final charges would dictate the nature of pretrial directions that should be taken. We take pretrial directions based on the final charges that will be subject of trial. We don't have that as minister. In these circumstances, and while it is true that this matter has already suffered considerable delay in court, the prudent order that commends itself to court would be to retain the mentioned date of 29 September 2021 to enable completion of the review process by the DPP, the learned DPP, the presentment of the final charges, a consideration of how that decision would impact on the existing pretrial directions or need for new ones, and also to determine whether the High Court revision, which has been brought to the attention of the court, would impact on the existing pretrial directions. As things stand, we're not even sure we have directions. That matter is still out there. It's a subject of decision. So all those things that would make this matter right for a hearing date are not concluded. They are not agreed. There are disputes around them. And it would be futile for the court to fix a hearing date in that cloud of doubt and circumstance. Therefore, my direction would be that we abide that date, that decision by the DPP, which, by the way, was instigated by the defense, and I agree that.
Hii gesi haina miguu, haina miguu. Hadi